This is Harry Droz, and you're listening to WNHHLP 103.5 FM, New Haven. You're listening to The Legal Eagle on WNHHLP 103.5 FM.
Welcome to the Legal Eagle radio show, where we explore the legal issues of the day, especially in Connecticut, where we originate. We look at the criminal and civil justice system, both at the state and federal level, and we talk to lawyers, judges, and folks connected to the law in various ways. Today, we are delighted to welcome Eric Higgins and Lenny Brauman. Tell us the formal name of your law firm and where you are located.
Good morning, Marcia. The name of our firm is Wofsy, Rosen, Kweskin, and Kuryansky. I want to add we celebrated our 100th anniversary last year, which we're very proud of.
Fabulous.
Thank you. And we're located in downtown Stamford.
That's wonderful. Okay, so you guys are just off a win before the Connecticut State Supreme Court.
That's right.
That will have dramatic impact on divorce judgments in this state. So thank you for joining us in our New Haven studio today. And I'd like you to sort of begin talking about this lawsuit, how it originated, what started it.
Yeah, well, thank you. And that's right. Before we get to the Supreme Court case, it's important to understand what brought us there. And it's quite an interesting tale, actually.
Yes, tell us the tale.
Well, it begins in some ways on October 2nd, 2007. When Gail Renke and Walter Singh were divorced after 18 years of marriage. They had two children, teenagers, 17 and 14 years old. Walter was a self-employed IT consultant, and Gail had been a stay-at-home mother for many years at that time. And as most cases do, as 90% of the cases do in Connecticut, more than that, this case was resolved not with a trial, but with an agreement, a separation agreement, which the judge then approved, and that became their divorce decree.
Did they go to lawyers before that? Or?
Yes, they had been represented by counsel throughout the process. And separation agreement was very detailed and covered all aspects of their divorce, including things like the division of their property, which they agreed was to be split 50-50, their bank accounts, their retirement accounts, and so forth. And also the alimony and child support that was going to be paid. And that was based on 40% of Walter's stated income, which he represented to be $100,000 a year at that time. So, in other words, $40,000 per year in alimony and child support. And all of this was based on, as it is in every case, financial affidavits that the parties had filed at the time of the divorce. In Connecticut, parties, when they get divorced, are required to file financial affidavits. And these are
legal documents?
These are legal documents. They're foundational documents in the divorce cases, and they're an inventory of the parties' income, their expenses, their assets, and their liabilities or their debts. And we'll talk a little bit more about financial affidavits later and the development of the law as it relates to them. But for present purposes, let's just say these are documents that the parties are supposed to be able to take to the bank. All right? They're sworn under oath.
Who under which oath? I mean, who's before a judge?
No, before a notary public.
Ah,
But they are sworn under penalty of perjury. You actually can be
okay.
prosecuted for perjury if you falsify, knowingly falsify these.
That's rare.
It is rare, right? But the point is, they are the equivalent of sworn testimony. These affidavits.
Mm-hmm.
So Walter and Gail are divorced, October 2nd, 2007, and they go on their way.
Mm-hmm.
In 2010, out of the blue, Gail receives a notice from the IRS.
Mm-hmm.
And the notice refers to a tax refund in the neighborhood of $100,000 that was for tax years during the period of the marriage.
Huh.
It's the first she'd ever heard about this. And
Is this addressed to her?
it was, I believe it was addressed to her. Yeah, it may have been addressed to them both, but she somehow received this.
Mm-hmm.
So she concluded that he stood to receive this large tax refund, about $100,000, which
That's
really
pretty
should have been divided at the time of the divorce. So
Right.
she got back in touch with her lawyer. We were not representing her in the divorce or at that time. And her lawyer moves to open the judgment. In other words, to open the divorce judgment to investigate this and see whether maybe this is something that she has a right to share in.
Mm-hmm.
In connection with that, he issues some subpoenas.
Her lawyer.
Her lawyer.
Mm-hmm.
He issues some subpoenas to banks, and he issues a subpoena to Ameritrade, where they had some accounts during the marriage. And the documents come into his office from Ameritrade. And Walter's lawyer files a motion for a protective order saying, look, the judgment has not been opened yet. There's nothing pending before the court. You don't have the right to run around issuing subpoenas when there's no pending case.
Mm-hmm.
And so the lawyers agree that these documents will be held in a sealed envelope until the judge has a chance to make a ruling on it.
Very dramatic.
Right.
Mm-hmm.
And so they go to court. And Walter's lawyer objects to Gail's lawyer having access to these TD Ameritrade accounts. Why? He says, well, I've already given her everything. There's nothing there. It's a fishing expedition.
The lawyer says.
Yes. It's a waste of time, and it's and so on and so forth. Well, ultimately, he loses, and the judge authorizes the unsealing of these documents. And lo and behold, there's another Ameritrade account with about $90,000 in it that he opened about a month before the divorce.
Mm-hmm.
All right.
So we're up to 190.
Now we're up to 190, and we're up to two different kinds of assets.
Mm-hmm.
And so then they go to court on the motion to open the judgment.
Mm-hmm.
All right. And the purpose being to open up the judgment, to do more discovery, to find out, is there anything else there? And if so, what do we do with it? If not, what do we do with the things we've already found?
Correct.
All right. And they get to court, and this is critical to what ultimately landed us in the Supreme Court.
Mm-hmm.
They don't have a hearing on the issue of fraud, which was the basis of her moving to open the judgment in the first place. Instead, they just agree. They stipulate and they agree that the judgment can be opened for this purpose, so that Gail can go off, do her discovery, do her investigation, and then the judge can decide what to do. And that's what happens. The trial judge in Stanford accepts that agreement. He opens the judgment just based on their agreement. And
as opposed to, just for our listeners, as opposed to looking at it through by fraud.
As opposed, right. The alternative would have been to have a full hearing.
Okay.
Like a trial, essentially, like a miniature trial on the issue of fraud, where you're calling witnesses, where Walter's testifying under oath, and so on and so forth.
Right. So,
And the point of that trial, that mini trial, would be to determine whether the judgment is even going to be opened or not.
right.
Not even how the assets should be divided if the judgment is open.
So he agrees to open. He agrees to open up the documents, correct?
Yes.
Why?
We don't know that, but there are good reasons to do that, let's just say in general. Okay?
Okay.
And among the good reasons to do that often are, it's expensive to put on this hearing.
Yes. Yes.
We all know legal proceedings it can be very, very expensive.
Right.
That's one. So he avoided, and they both avoided the legal expense.
Okay.
Another thing people avoid by doing that is the emotional toll of contested court hearings. Now, for some people, it doesn't bother them. For some people, it really bothers them. It's very hard on people emotionally to go through that, particularly with a spouse or a former spouse. It's loaded emotionally.
Right.
And it's stressful for a lot of people.
It's loaded. It's loaded.
And so that was avoided. Another good reason to avoid that, if you're in his position, or actually in either one of their positions, is if you have a hearing on the issue of fraud and the judge finds that you committed fraud, there are other consequences, some nasty ones that can flow from that. In his case, he was a self-employed IT consultant. Among his clients was a prominent law firm. Well, so, who knows whether if this had come out, the law firm would have continued, or his other clients would have continued to use him, or if he had just been a regular W-2 employee, whether that perhaps could have had adverse employment consequences for him. And so the risk that a judge makes a public finding based on the evidence that you have committed fraud is a risk that oftentimes people are wise to avoid.
I see. Okay.
So off they go. We were hired a couple of months after that, and we did a lot of discovery, an investigation, and among them, all of this had to do with income. He had represented, now remember, he had represented on his financial affidavit when they were divorced that his income was $100,000 a year. All right. We asked him, well, produce whatever proof you have of that, W-2s, 1099s, tax documents. I don't have any.
I don't have any.
All right. That was the response. I didn't receive any. We said, well, you work for a law firm. I would have thought that you would have received documents like this. Well, I didn't. All right. Well, so then we moved. The law firm's in New York that he was working for. And so we had to move for court permission to issue a subpoena in New York to get these documents, to show how much they were paying him in 2007.
Right.
And again, it's a motion for protective order. It's a fishing expedition. There's nothing there. I've already told her how much I was earning.
By the way, when your opposing counsel tells you you're on a fishing expedition, keep fishing.
That's good advice.
That's a good headline.
And so the judge ultimately denies that. She gives us permission to go to New York to have the subpoena issued to the law firm to get their documents sort of from the horse's mouth, right? What he is being paid. Well, it turns out his total income, in round numbers, they were paying him like 150, not 100, and plus he already acknowledged making like another 30 from other sources. So the point is, now we had evidence that his income was about 180 at the time of the divorce when he said it was 100. In addition to these other assets, and the discovery also revealed another 3 or 4 assets that he hadn't disclosed worth well into the 6 figures. Okay, so we had quite a bit here, we thought, and also, we felt that it wasn't just one thing, right? Anybody could forget an account,
right?
But this seemed to be a pattern to us,
right?
And so we go back to the trial court eventually, and in 2013 we have our trial. It took place over 6 days. And in August of 2013, the trial judge issued a written decision, and he found that we had proven all these things that I just described, the income that hadn't been disclosed, the assets that hadn't been disclosed. And essentially what he did is he divided the new, I'll call them the new assets, 50-50 in her favor. The same split you may remember as they agreed upon for the assets at the time of the divorce. And with respect to the income, he increased it by like 10%. All right. And actually shortened the alimony period, which didn't explain why, but he actually shortened the alimony period. So in some sense, it was a win. But we were dissatisfied with it. And the reasons we were dissatisfied with it is, number one, we felt that divide assets that had been concealed,
Mhm.
right?
Right.
The same way they were divided if they were not concealed,
Mm-hmm.
actually puts the incentives all in the wrong place,
Mm-hmm.
we argued. In other
Mhm.
words, you know, a rational person, an amoral rational person would decide, well, I'm better off not concealing some things. Worst thing that happens, they get divided the same way they would have been divided had I disclosed them, and hey, maybe I get away with it.
Right.
So we thought that was unfair. She got a small fraction of her legal fees, which we felt was unfair after we had proven all these things. And we felt that the alimony increase was not high enough, an extra approximately 10% when his income was about 80% higher than he had disclosed. And we argued that it was unfair for him to shorten the alimony period.
Mm-hmm.
There was no allegation that she had done anything wrong. And so she appealed. Yeah, and she appealed to the Connecticut Appellate Court in Hartford. And do you want to talk, Lenny, about what happened there?
Okay, Lenny, you're on.
Absolutely. So we were the appellant
Mm-hmm.
on the appellate court, and the issues were, you know, whether the trial court, the trial judge, in making his decision on how the assets and the alimony should be reallocated after the judgment was open, made the correct decision, or whether he awarded too little in various categories. The appellate court had just decided, while our case was pending in the trial court, a couple of decisions that had addressed the question of a trial court's quote-unquote subject matter jurisdiction to reallocate assets and income from a divorce after the divorce was final, and had determined in a number of those cases that the trial court did not have subject matter jurisdiction.
Could you explain that to our listeners?
Exactly. So subject matter jurisdiction is, in very brief terms, it's the power of a court to hear a particular type of case.
Oh, okay, right.
And that's very different from whether the court this is deciding the case rightly or wrongly, or whether the court has made the appropriate decision under statute. That's a question of the court's authority under the statute or under the common law. Subject matter jurisdiction. My law professor in law school told us that it's really whether the court has it's like the electricity in the house. If the electricity isn't on, you can't even turn the lights on.
Right.
So subject matter jurisdiction also is a question that even if the parties agree that there is subject matter jurisdiction, that the court has the authority to hear the case, the court has to decide on its own whether or not it does. And that's so the court actually has an obligation to determine whether it has the power to hear the case or not. Now, in general, trial courts have subject matter jurisdiction to hear divorce cases and family cases. But there was some law that suggested that, and particularly there was the use of the word jurisdiction in the statute that allowed for opening of judgments, not only in family cases, but in all cases, foreclosure cases, civil cases generally. The legislature had used the word jurisdiction in that statute. And some years ago, there was a Supreme Court case that said, well, when the legislature said jurisdiction, they didn't necessarily mean subject matter jurisdiction. They weren't talking about the power of the court to hear the case at all. They weren't talking about whether the court had to determine on its own whether or not it had the power to hear the case. They were talking about something called personal jurisdiction, which is or whether the court has power over individual people. And then a couple of years, some years later, they said, well, actually, that statute doesn't really mean personal jurisdiction either. It's got to mean statutory authority.
What was the end result?
The end result is that in a case called Baby Girl B, the court decided that the statute about opening a judgment deals with the court's statutory authority, whether the court is going to decide one way or the other whether to open the judgment or not whether the court has the power to hear the issue. Okay,
Right. Right.
So but the appellate court had some decisions that said in family cases,
Mm-hmm.
the trial court doesn't have subject matter jurisdiction just based on the parties agreeing to open the judgment.
So, in other words, this case sort of walked into a real difficult kind of procedural reality. That you know, in other words, because I'm sitting here and I'm wondering, you know, this issue must have come up before your case. I mean, a zillion times, and yet nothing happened all these years.
It had come up before, and
Okay.
and there were some conflicting decisions, and that was part of the problem. The root problem was that the statute that governs the opening of judgments provides that, generally speaking, it has to be done within 4 months of the judgment. Now,
I see. There was a time limit. Okay.
exactly. Back at the beginning of the show, if anybody remembers, this was 3 years after the judgment, so they were
Right.
way outside
Oh.
the 4-month period.
Mm-hmm.
But the statute also says that 4-month period can be waived.
Mm-hmm.
So that was an issue in our case, and so we had taken the position that, of course, it was waived. They agreed that the judgment could be opened.
Mm-hmm.
What ended up happening in the appellate court was we went up, we filed our legal briefs, and we went up for oral argument, presented the case. This whole process took about 1.5 years.
Wow.
And we're waiting for a decision. Every day the mailman would come. We'd ask the mailman, do you have anything for us from the appellate court? And he'd say no. And one day the mailman did have something for us for the appellate court. And what they did is they did something very unusual. And they issued us what's called a sua sponte order, meaning an order on their own initiative. No one asked them to do it. They just did it on their own to the trial judge and said, we order you to state specifically whether you're finding that fraud was committed. Because the trial judge never said one way or the other whether this was fraud. He just said there were assets that were not disclosed. There was income that was not disclosed. Now, that may sound like fraud, and it is similar to fraud. But, you know, from a technical legal standpoint, fraud requires a couple more things. It requires proof of intent to deceive. There's a higher burden of proof. It's a clear and convincing standard of evidence. So the appellate court, to us out of the blue, says to the trial judge, tell us whether or not you're making a finding of fraud. And we wait and we wait and we wait. And then the trial court issues a written decision, bottom line of which is no, I'm not finding fraud. So then the appellate court issues a second sua sponte order. As I said, one is unusual. Now we have two in this case. And the second one says, we want the parties to file additional legal briefs on the issue of whether, and getting back to what Lenny was explaining about subject matter jurisdiction,
Right.
the absence of a finding of fraud deprived the court of subject matter jurisdiction. And so they put this issue on the table, and we file additional briefs.
Yeah.
And here's the interesting thing. So we filed a brief that said, we think the trial court had subject matter jurisdiction. We think it had the authority to decide these issues. And the husband's attorney, our opponent, also filed a brief that said, we think there was subject matter jurisdiction too.
Oh, that's interesting.
But remember, the appellate court, has to determine independently whether the court thinks there was subject matter jurisdiction.
Right. Right.
Right. And it's not enough that the parties agree.
Right. It's not enough.
And so it's all finally teed up, and eventually the appellate court issues its decision, and it dismisses the whole appeal and dismisses everything that happened below, saying that there was no subject matter jurisdiction as a result of the failure to find fraud, or the absence of a finding of fraud. Everything's dismissed. It's a catastrophe for us. It's a catastrophe for our client, because remember, she appealed. And now she's not only lost the appeal, but lost all of the benefits that she had won after years of litigation. Right?
Right. No,
It's all gone.
Right.
And the implication of that was that this guy got to keep all the things
No
that
question.
the trial judge found that he had not disclosed. It was perverse. Nevertheless, that was the decision.
Okay.
The result was perverse. I'm not saying that the
Yeah,
legal
no,
reasoning
I
was,
understand.
but the result was
Right.
hard to
Hard to
reconcile.
hard to reconcile.
Yeah.
Which appellate court was this?
The Connecticut Appellate Court.
No, I know, but which district?
There's one. It's one appellate court sits in Hartford for the entire
in the
state.
Hartford for the whole thing. Oh,
Yeah.
for this particular. Okay.
Yeah.
To our listeners, you are listening to WNHLP 103.5 FM. We are broadcasting live from downtown New Haven. We are streaming live on TuneIn Radio and NewHavenIndependent.org. And we are also streaming live video on Facebook Live. So go to Facebook Live or wherever you'd like and join us. Okay, so this is crazy.
Yeah, so here we are.
Where you're at right now.
Right.
We're back to square one, basically.
You're basically back to square one, and nothing, and really neither side is, well, certainly your client is not helped at all. It's crazy because she loses everything. So then what happens?
Well, turn it over to Lenny again. But the next thing is our only option left is to ask the Supreme Court to take our case.
To take a look. Right.
That's the next court up, and of course, it's the highest court in the state of Connecticut. So this is.
But meanwhile, just at this point, just from not a legal point of view, but just a life point of view, what we have here, as you lose this, as the appellate court rules, is a person involved in a divorce, for want of a better word, can commit fraud, cannot reveal or disclose to his or her partner the actual assets and financial dealings of his life, has kept that concealed, which frankly might be a crime, but who knows, and that's okay. That's okay. I mean, how did we get to the point where there are lawyers involved and there's deceptive filings, and you can get away with that?
Well, it was awfully frustrating to us, and I suppose that the way I would say it is not that it's okay, but that there are some wrongs in life and grievances in life for which the courts simply don't provide a remedy.
Ah, okay.
I'll give you an example. There are many torts, right?
Mm-hmm.
Situations where someone causes another one to an injury.
Mm-hmm.
Well, that's not okay. But at the same time, there's no remedy for that unless you bring it within the statute of limitations.
But in this case, it was only 4 months, right? Or 3 months?
It was 4 months.
4 months.
Yes,
right.
Very short. And so I think that's, to be fair to the court,
Mm-hmm.
I think that would have been the court's response to that question. Not that it's okay, but that there's not a remedy for every wrong in life.
Right.
Through the courts.
Right.
Okay.
Right.
And so, anyway, here we are, and in our last chance, we got one shot left.
We have one shot left, the Supreme Court,
and
right?
the Supreme Court, which does not have to hear our case. In fact, the Supreme Court declines to hear most of the cases it's asked to hear.
That's right.
So again, Lenny was very much involved in that process, and so we set about to convince the Supreme Court that our case is worthy of their time.
So this was actually shortly after I had started at Officer Rosen. Eric came into my office and he said, I need you to help me with a petition for certification to the Supreme Court. And I said, oh boy.
I think I was breathing heavily, agitated. Yes.
That's not easy.
Because
Yeah.
I knew how rarely those are granted.
Right.
And you have to convince the court to exercise its discretion to even hear your case in the first place.
Mm-hmm.
And there's criteria that you can try to fall within. For instance, if there's some confusion in the law among different decisions of the appellate court, which there had been here, if there's decisions of the Supreme Court that
Mm-hmm.
you think are contrary to what the appellate court did, if it's an issue that's important that the court really should take a look at, that's going to affect a lot of people. But even if you can show one or more of those, you're not guaranteed to have the court hear the case, because the court has such a big docket. They only focus on cases that are of the most importance, where there's really a wrong committed that they have to change the law with. Now, so we submitted a petition for certification, and the court, fortunately for us, granted that petition for certification, and they limited the certification to a single legal issue, which is common.
Mm-hmm.
And the legal issue was, did the appellate court have subject matter jurisdiction? Did it have the power to hear the case,
Mm-hmm.
even though the trial court found that that fraud wasn't proven here?
Mm-hmm.
And what it comes down to is, do you need to show fraud in order to have a do-over, in order to reallocate the assets.
Right. That's a high, yes, okay. Yeah.
Or can parties, as they did here, agree that we're not going to try to have a trial on fraud. We're not going to go through a whole long, drawn-out, expensive process of proving whether fraud was committed. We're just going to try to redivide the assets and let the court decide what's equitable, what's fair in terms of the division.
And that was the decision of the Supreme Court?
Yeah, but one of the another unusual and I think somewhat interesting aspect of all of this is that there were 2 amicus briefs filed.
Yes.
And it's unusual, certainly in family cases, but I think unusual generally for amicus briefs to be filed at all. Now, some of your listeners, I'm sure, know an amicus brief is simply a legal brief, a written legal argument that's submitted to the court by, usually it's an organization that's not a party to the case, but their organizational mission relates somehow to the issue that's before the court. So here we had not one of those, but 2 of those. And I don't ever remember a family case that had 2.
This is the Connecticut Bar Association and the American Academy of Matrimonial Lawyers. And you know, the reason that they submitted amicus briefs, that they stated in their briefs, was that they thought there was a policy issue here, an important public policy issue. And that issue is whether the courts are going to, in a sense, force parties who have been divorced to go through a trial on the issue of fraud in order to reallocate their assets,
right,
or whether they can agree to do it. And there is already a strong policy in state law that you have married couples whose assets should be divided between them and their children and used for the family. You don't want to unnecessarily make them spend money on legal fees. And so the strong policy is to encourage settlement and agreement wherever possible. And that's expressed in cases. And the amicus briefs that were submitted to the Supreme Court in our case said, if you make parties try the issue of fraud, if you make them prove fraud in order to reallocate, you're contravening that policy. You're telling people that you can't settle. You have to try. You have to try the case.
If you want the right to wrong, so to speak.
That's right. Even if you would rather settle and have, the court redivide the assets.
During the course of your investigation and reading, what did you find out about other states?
Well, this is an issue, obviously, that's come up in other states as well. And there's one California case that's become something of a legend that I just came across recently. In that case, it was pretty dramatic. A wife who was married at the time won the lottery.
She won the lottery?
She won the lottery.
Oh, that's a good one.
She was already thinking about divorcing her husband at the time.
When she won the lottery.
Correct.
And he said, I want half.
And so she actually filed for divorce before she got the payout, the first payout.
Before, okay.
And the divorce was finalized, and they had a separation agreement, which perhaps the wife hadn't read. It said that if there's assets that are concealed, the one who the one who concealed them loses 100% of that asset that they've concealed. Okay. Now, the wife didn't tell the husband in her financial affidavit, or the equivalent in California, that she had won the lottery and that she was expecting $1 million payout. Some years later, after the divorce was finalized, the husband got something in the mail from the Lottery Commission in California saying
he went years without knowing that his wife had won the lottery while they were married.
How do you not know your wife won the lottery? It's in the newspaper.
That's right. So he after his job picked up from the floor, he got a lawyer, and they moved to open the judgment, the same as in our case. And the judge said, you concealed the lottery winnings from your husband intentionally. Under the separation agreement, he's entitled to 100% of that lottery winning.
Right.
So this is something that...
And she gave it to him.
Yeah.
Right?
Yeah. Well, then she appealed to the highest court in California. With she had a couple of arguments of why she thought she was entitled to keep the winnings. She said, it was a gift and so forth, and the court rejected that. But the upshot is, this is a dramatic example of it, but it's the kind of thing that can happen. And one of the ways, and Eric can speak to this, is one of the ways you can try to protect against this risk.
Mm-hmm.
If parties have a separation agreement when they're divorced, you can put in a clause that says, if you conceal something, the other spouse is going to get 100% if it's determined.
So and that would make sense because there's a penalty in effect if you conceal.
Right.
Okay.
Right.
Right. But going back to the beginning here, I mean, it seems that initially you could conceal, for want of a better word, but you could conceal when you signed the papers because the notary stamped it and nobody was really looking at it. I mean, is there an obligation for the lawyer for this husband?
Mr. Singh.
Mr. Singh.
Yeah.
Was there an obligation on the part of his lawyer to make sure that these documents were accurate? I mean, under the ethics rulings and so forth regarding lawyers?
Right.
Or am I in a new place here?
No, that's an excellent question. And it's a tricky one. It's a tricky one for lawyers. But here is what I believe the answer to be. Certainly a lawyer is prohibited from submitting any document, and certainly including a financial affidavit to the court, that lawyer knows is false.
Correct.
No question about that. That's an easy one.
Mm-hmm.
The harder one is whether the lawyer has any obligation of independent investigation.
Right, to determine whether that's true or not.
That's right. And I believe in general the answer to that is no.
Mm-hmm.
However, at the same time, at a minimum, I think that responsible and ethical lawyering requires some reasonable effort on the part of the lawyer to satisfy himself or herself that the client is being candid, all right, on the affidavit. So at the same time, lawyers really, in general, don't have the ability to go behind the information that the clients are giving them. Now, for example, we don't have the ability to call up Ameritrade and say, hi, I represent Mr. So-and-so. He's disclosed 3 Ameritrade accounts. Are there any more? We just don't have the right to do that. And nor do we have the right to find out what their bank accounts are or to contact their employer and to say, I just want to make sure that Mr. Smith, my client, is telling me the truth about how much he's being paid. We don't have the right to do that. And in fact, if we do that against our client's instructions, that's probably an ethical violation.
Because you have a duty. You have a duty of zealous advocacy to your client.
Right.
Right. So it's the countervailing principle.
Yeah.
But this is a very tricky problem for lawyers.
This is a very tricky and a way, and one could maneuver. Let's use that word in and around it. Are divorce proceedings open to the public in Connecticut? I think they are.
Yes, they are. No question about it. Now,
because they're not in all states.
That's right. Now in Connecticut, it's very rare, but there is a process for either sealing certain documents or closing the courtroom for the entire proceedings. Now, I'm not saying it hasn't happened. I'm not aware of a divorce case where the court closed and locked the door to the courtroom for the proceedings. However, there is precedent, certainly, for sealing certain documents. In fact, oftentimes financial affidavits. For privacy reasons, sometimes for companies have an interest in their who employ people, for example, have an interest in their financial information not being made part of a public proceeding. It's proprietary information, and there's and the company owns it. So sometimes those things will be documents will be sealed, but even that's unusual. In general, these things are open to the public.
They're open, at least in the state of Connecticut. And you are listening today to the Legal Eagle, and we are broadcasting live from downtown New Haven, and we are streaming live on TuneIn Radio. We are also streaming live video on Facebook, so check out Facebook and you'll find us. So now the final holding from the Connecticut Supreme Court comes down last month, right? And what does it say? Essentially, to those folks out there who are in the process of getting a divorce. By the way, how many divorces do we have? Do we know in Connecticut yearly?
I don't have that exact number. It's certainly it's thousands.
Thousands? Oh,
Sure.
Yeah, clearly
yeah.
thousands.
Yeah.
Right.
I mean, well, let's face it.
We have that many.
About
more.
half of all marriages wind up in divorce.
Correct.
40% of first marriages and like 60% of second marriages.
Is that right?
Yeah. And even and more than 70% for third marriages.
Is that right?
Yes.
I had
yeah.
no idea.
Those are the statistics. Those are national statistics. I don't have Connecticut specific on
But
those.
I understand that Connecticut has a relatively low rate of divorce compared to other states. But there's still quite a bit of divorce that affects a lot of people. The Supreme Court held that the case had to go back to the appellate court because the trial court did have subject matter jurisdiction.
Okay.
And
so
now
they sent it back.
They sent it back to the appellate court, and they told the appellate court to look at the issues that we raised in our appeal to the appellate court in the first place.
Which they had never addressed because they had determined there's no need to address these issues because there's no subject matter jurisdiction. The whole kit and caboodle is dismissed, so there's nothing else for us to look at. And so now the Supreme Court has said to the appellate court,
look again.
Well, that was wrong. The trial court did have the authority to hear the case. You have the authority to hear the case. And so...
so don't tell me you're back in court.
We are back in court, yeah, and continuing to litigate a motion to open the judgment that was filed in 2010.
Wow.
We're 8 years later, and we could be easily a year or more. There are a number of pathways that the case could take. I mean, it could end in the appellate court. We could lose. That would be the end of it.
Why couldn't you?
Well, it's possible we could lose and we could go back up to the Supreme Court again. That depending on the nature of it.
Depending on what happens, yes.
It could be that we win, and that's the end of it. Or we win and the other side appeals to the Supreme Court. Or we win and it goes back to the trial court to rehear some part of the case. Maybe not the whole thing, but some portion of it. And there are more proceedings, which then can go back up on appeal. So it's... what we can tell you is we're not done yet.
What do you think of this whole process? I mean, not the process of the divorce, just how this statute was written originally and what you're facing now and what couples who, I mean, obviously the wife did not know her husband's income. Now,
Well,
I knew my husband's income because I wrote the checks. And so did he. I mean, so what is it that can happen here that could make this process a little bit easier?
Well, in many ways, the process has been working, and the law is responsive to this. Now, the law commits judgment calls oftentimes, and many of them, to the judgment of individual trial judges, right? And they're people just like you and me, and they each have their own points of view and their perspectives and their sensibilities. And they're not perfect like any of us.
Right.
And but, well, certainly in this sense, the system has worked in that the Supreme Court, of course, we believe got it right. Okay. It made clear that the courthouse doors should be open to people in this circumstance who just want to agree to move on and be practical and not have to have a hearing over this issue.
Let alone a fraud hearing.
Let alone a fraud hearing, right. And has agreed that we're entitled to our day in court on the issues that we raised in the appellate court. Now, it's been terribly...
That's big, that's a major change in the thinking of the courts, right?
That
you don't need to go through the fraud.
It had been unclear, and one of the things that the Supreme Court is charged with the responsibility to do is to make the law clear where it was previously unclear.
Right, where it was ambiguous. Okay.
And
so that's big.
Yeah, it's very important. And so to that extent, I think the system's worked well. The development of the law in this area, meaning the area of financial affidavits, how important they are and how important it is for courts to enforce them, has been very good in my opinion over the years, in really the modern era. I mean, it goes back to 1991 in a case called Billington versus Billington. Before Billington, a party who was in our client's position had to show, among other things, that she exercised, quote, due diligence, close quote, during the divorce to find out what her husband's assets and income were. And so she would have been vulnerable to a claim that, hey, it's your fault, you should have known, you didn't do a good enough job in discovery. In 1991 in Billington, the Supreme Court eliminated the due diligence requirement and essentially said a number of things that are very important to this day. She doesn't have any responsibility to do that. That's his job.
Right.
He's the one with the information. It's his job to be honest about it. And it's not fair to put on her. I'm just using the genders that were at issue in my case. It could be either way, depending on the case, right? That's not her responsibility. So that became very clear. The court also talked in fairly flowery fashion, I think, about the nature of the marriage relationship, even when it's breaking down. And it talked about how it's a unique human relationship. It's unlike a business deal. It's unlike another kind of court case in terms of the obligation of transparency between people. There's an intimacy. This is all in the court's decision. This unusual stuff for a Supreme Court decision. But the court talks about that, and it says that the obligation of a spouse, even when the marriage is falling apart, to be transparent with their other spouse is like a fiduciary obligation, which of course, is among the highest obligations in the law of transparency. And therefore, it said that these financial affidavits are terribly, terribly important for two reasons, both as a matter of justice in individual cases, meaning so that people can make intelligent decisions based upon what the facts really are, but also as a matter of justice in the systemic sense, in that the system, as Lenny was explaining before, wants to encourage people to settle their disputes in a way that's reasonable. That's right. And the system depends on people being able to do that. I mean, as I said before, 90% of these cases settle. We don't have the resources to try 15%, let alone 100% of the cases.
In fact, we try very little.
We try very little, and we can't. And so these financial affidavits have to be accurate. You know, the Supreme Court in Billington explained as a so that system can work the way it's supposed to work. And so back in 1991, the Supreme Court really put a flag in the ground in a case called Billington. And since then, we can talk more about it if you like, but there have been a couple of key cases along the way that in general terms have just reaffirmed this on the Supreme Court level that the trial courts really have a heavy obligation to enforce this.
Okay. So that's a very good analysis. And it looks like our time is up. It goes very fast when the topics are so interesting, and we will have Eric and Lenny back because we definitely want to know how this case works out. We want to thank you both for coming to the studio today to tell us about the latest twist in divorce cases, which affect many, many couples in the state. And to our listeners, you can go to the NewHavenIndependent.org website. You can get a podcast of this broadcast. You can listen to a variety of other shows that the station is producing each day. And we thank you for joining us today in New Haven.
Thank you for having us.
Thank you so much, Marcia. It was really our pleasure.
Okay, thank you.